In cross-examination, I can possibly trip the officer up. One of my favorite cases was when an officer who typically testifies well, I was objecting to things that I was objecting to things that I knew would probably not be sustained by the judge. The officer was having trouble laying the proper foundation, and I would object every time he said the speed because he didn't lay the proper foundation, and the judge was sustaining all of the objections. By the time the officer was done testifying, his testimony was my client was driving 82 miles per hour, but in an 82 mile per hour zone. So after his testimony, the judge looked at me and said, "Mr. Athen, do you have any questions of the officer?" And I looked at my notes to make sure I wrote down what I thought I heard, looked at the officer and said, "No, Your Honor, I don't think I do." I said, "I believe the testimony before the court is my client was driving 82 miles per hour," and the officer, he finally got that in, but in an 82 mile per hour zone. Now, I don't know where an 82 mile per hour speed limit is in the state of Maryland. 65 is the highest, but the state's evidence is my client was driving the speed limit. Therefore, it should be a judgment of acquittal or not guilty. And the judge kind of laughed and looked at the officer and said, "Officer, where exactly is this stretch of road again? Because I want to go drive on it," and proceeded to give me the not guilty for the case.